There are many people who entered the United States without inspection and received a removal order after going through removal proceedings who are now married to U.S. citizens or who have other qualifying family members who could petition for them. And they do not know that they, in fact, oftentimes can do the consular process and seek stateside waivers in the United States in order to obtain their green card. So let's talk that out. Let's say Joe enters without inspection, he goes through removal proceedings, and he just loses. He files an asylum case, loses. Joe never departs the U.S., later marries a U.S. citizen. Now that U.S. citizen wants to petition for him. What do? The U.S. citizen files the I-130 for Joe. Then you need an I-212 waiver to be approved to waive the inadmissibility due to the removal order, okay? And then after that's approved, do the I-601A waiver, which is going to cure the unlawful presence prior to leaving. So then after those are approved, and the I-601A can't be approved until the I-212 is approved, then you would go send your, case would be sent to the NVC, then you would do the NVC process and eventually do your interview abroad. Now, many people don't know that this is a possibility with a removal order. It does not work if you've already left the U.S. and then re-entered. In some situations, as you entered with advanced parole, we could explore that. But let's just assume you have not left. In that case, you can do the I-212 and then the I-601A waiver. Now, what about if it's an in absentia order of removal? The I-212 will address the removal order itself. However, you may have heard about a 5-year bar for people who failed to show up at their removal proceedings. In practice, or in legally speaking, that 5-year bar does apply. In practice, some consular offices essentially treat the I-212 waiver for the removal order as also having cured that 5-year bar. However, it is a risk, and I advise you to speaking with your attorney prior to traveling outside of the country after the grant of an I-212, I-601A, if your removal order was in absentia.